Let's begin with a fundamental question. What does it mean to hold power accountable? Not in theory, not in campaign speeches, but in the messy reality where rubber meets the road. This is the question at the heart of our discussion today about the Leahy Law, one of America's most important yet underappreciated tools for preventing U.S. complicity in human rights abuses abroad. I want to take you back to where this all started, the early 1990s. Picture the aftermath of El Salvador's civil war, where UN investigators were exhuming mass graves containing the remains of civilians slaughtered by US-trained battalions. Recall the genocide in Guatemala, where State Department cables later revealed American officials knew about the atrocities even as military aid continued flowing. These weren't abstract human rights violations. They were children burned alive in villages, priests shot at their altars, students disappeared from university campuses. And in too many cases, the weapons and training came from the United States. This is the soil from which the Leahy Law grew. Senator Patrick Leahy looked at this bloody history and asked a simple, moral question. Should American taxpayers fund security forces that torture and murder their own people? The answer became 2 paragraphs of legislation that changed U.S. foreign policy forever. But as we'll explore over the next half hour, passing a law is just the beginning. The real work is in enforcement, in daily accountability, in overcoming the countless ways powerful institutions resist constraints. Let's examine what the Leahy Law actually does at its most basic level. It prohibits 2 categories of U.S. assistance. First, State Department funds under the Foreign Assistance Act and Arms Export Control Act. Second, Defense Department training and equipment under Title X. The prohibition triggers when there's credible information that a foreign security force unit has committed gross violations of human rights. But here's where things get interesting. Neither of these key terms were originally defined in the law itself. This ambiguity creates both opportunities and challenges for accountability. On one hand, it allows flexibility to respond to evolving human rights crises. On the other, it gives bureaucracies room to maneuver around restrictions. Let me break down how this plays out in practice, starting with what constitutes a gross violation of human rights. The State Department eventually adopted definitions from other parts of U.S. law, focusing on several core crimes: torture, extrajudicial killing, forced disappearance, and rape under color of law. But consider how each of these manifests in real-world scenarios. Torture isn't just waterboarding in black sites. It's electric shocks to genitals in Mexican police stations, beatings with rubber hoses in Egyptian prisons, forced stress positions in Philippine safe houses. Extrajudicial killings aren't just firing squads. They're Philippine police planting guns on drug war victims, Cameroonian soldiers executing villagers and calling them terrorists, Colombian paramilitaries dumping bodies in mass graves. Now, let's talk about credible information, the threshold for triggering Leahy vetting. This is where accountability lives or dies. The law intentionally sets a lower bar than criminal courts require. Why? Because in countries where justice systems are broken or complicit, waiting for convictions would mean waiting forever. Instead, the State Department looks for information that's deserving of confidence, a standard that can include NGO reports, victim testimony, investigative journalism, even leaked documents. But here's the catch: who determines what's credible? In theory, it's the Bureau of Democracy, Human Rights, and Labor, DRL, at state. In practice, it's often a tug-of-war between human rights professionals and regional bureaus more focused on diplomatic relationships. I've seen cases where exhaustive documentation from groups like Human Rights Watch gets downgraded to unverified because a foreign government denies it. This is where accountability breaks down unless outside pressure is applied. Let me give you a concrete example from my own experience working on these issues. In 2016, we documented a pattern of rapes by a particular Nigerian military unit that had received U.S. counterterrorism training. The evidence included medical reports, survivor testimonies, and internal military documents. Despite this, The unit remained eligible for assistance for 18 more months because investigations were ongoing. Only after congressional staff started asking questions was the unit finally vetted out. This delay represents 18 months of potential victims who might have been spared if accountability mechanisms worked faster. This brings us to the INVESTc system, the database where Leahy vetting theoretically happens. It's supposed to be the central nervous system of human rights vetting, tracking units and individuals across all U.S. security assistance programs. But having reviewed its implementation across multiple administrations, I can tell you it suffers from 3 fundamental flaws that undermine accountability. First, it's only as good as the information entered. In many embassies, security assistance officers are overworked and undertrained on human rights vetting. Critical data gets missed. Second, the system relies heavily on self-reporting from foreign governments about their own abusive units, a clear conflict of interest. Third, there's no independent verification mechanism to check whether units placed on the prohibited list actually stop receiving assistance through other channels. Now let's talk about waivers and exceptions, the escape valves built into the Leahy framework. The State Department can override Leahy restrictions if they determine a foreign government is taking effective steps to address abuses. The Pentagon has an even broader national security waiver. In theory, these should be rare exceptions. In practice, they've become routine workarounds. Consider Egypt, one of the largest recipients of U.S. military aid. Since 2013, multiple Egyptian security force units have been credibly implicated in torture and forced disappearances. Yet year after year, the State Department invokes the effective steps exception, citing sham military trials that convict low-level officers while the torture apparatus remains intact. This isn't accountability, it's accountability theater. The Pentagon's national security waiver is even more problematic. Under Section 362 of Title 10, the Defense Secretary can bypass Leahy restrictions for extraordinary circumstances. What counts as extraordinary? The definition is so vague it could cover almost anything. In 2019, this waiver was used to continue assistance to a Saudi military unit implicated in the Yemen war crimes, citing counterterrorism cooperation. This brings me to congressional oversight, theoretically the backbone of Leahy accountability. The law requires regular reporting to the Senate Foreign Relations and House Foreign Affairs committees. But having worked with these committees, I can tell you the reality is more complicated. Most committee staff are handling dozens of countries and issues simultaneously. Leahy reports often get filed away unless outside groups bring specific cases to their attention. The appropriations process, where Leahy originated, has become so rushed that few lawmakers actually read the human rights conditions attached to security assistance. And perhaps most critically, there's no permanent investigative body dedicated to Leahy enforcement, no equivalent of the Government Accountability Office, GAO, for human rights vetting. This institutional weakness creates accountability gaps that civil society must fill. Organizations like the Center for Civilians in Conflict and Amnesty International have become de facto Leahy watchdogs, tracking U.S. security assistance and matching it against human rights violations. Their work is heroic, but it shouldn't have to substitute for proper government oversight. Now, let's talk about remediation, the process by which banned units can be reinstated after reforms. In theory, this is the carrot to complement Leahy's stick. In practice, it's become another accountability loophole. The standards for remediation are dangerously vague. What constitutes effective steps to bring perpetrators to justice? Is it enough to convict a few low-ranking soldiers while the command structure remains unchanged? How do we measure genuine institutional reform versus cosmetic changes? Too often, remediation decisions appear driven more by diplomatic convenience than verifiable progress. I want to share a success story to show how accountability should work. In Honduras, after the 2009 coup, U.S. assistance continued flowing to security forces despite mounting evidence of abuses. It took years of persistent documentation by local activists, combined with pressure from U.S. NGOs and congressional allies, before Leahy restrictions were finally imposed on several police units in 2012. The key factors that made this work: 1. Ground-level human rights monitoring that could link specific abuses to specific units. 2. Strategic partnerships between Honduran and U.S. organizations. 3. Congressional champions who demanded answers. 4. Media coverage that raised public awareness. This multi-pronged approach is the model for effective Leahy enforcement. But it shouldn't require this much effort to uphold the law. Looking globally, we see both the promise and limitations of Leahy-style accountability. In the Philippines, Leahy restrictions did block assistance to some units implicated in Duterte's drug war killings. But broader military aid continued through other channels. In Mexico, Leahy vetting has removed some abusive officers from U.S. training programs, but hasn't stopped the flow of weapons to corrupt state police forces. This brings me to structural reforms needed to strengthen Leahy accountability. First, we need clear, public criteria for what constitutes credible information and effective steps not left to bureaucratic discretion. Second, the INVESTc system needs independent audits to verify its accuracy. Third, Congress should create a dedicated Leahy oversight office with subpoena power. Fourth, waiver decisions should require public justification with evidentiary standards. But ultimately, laws are only as strong as the people demanding their enforcement. This brings me to your role in this accountability ecosystem. Whether you're a student, journalist, activist, or concerned citizen, here are concrete ways you can contribute. 1. FOIA requests for Leahy vetting records. Templates available from the National Freedom of Information Coalition. 2. Building relationships with human rights defenders in security assistance recipient countries. 3. Tracking security assistance through databases like Security Assistance Monitor. 4. Pressing your congressional representatives to hold Leahy oversight hearings. 5. Supporting investigative journalism that follows the weapons trail. The Leahy Law represents a radical idea that America's strength comes not from unchecked power, but from moral consistency. That we're safer when our allies respect human rights, not when we excuse their abuses. That accountability isn't an obstacle to security, it's the foundation of lasting security. As we conclude, remember this: the Leahy Law didn't emerge from government benevolence. It was born from scandal, from outrage, from citizens demanding change after seeing U.S. weapons enable atrocities. Its continued strength depends on that same democratic pressure, on our willingness to ask hard questions, follow the evidence, and insist that our government's actions match its professed values. Accountability isn't a spectator sport. It requires showing up at town halls, in congressional offices, in the pages of local newspapers. The tools exist. The law is on the books. What's needed now is the collective will to use them. Thank you,